Court reporter, I'm trying to protect you.
Thank you, Judge.
All right. Deputy Laura, do you want to
what
like
court
step
is-
over?
He's always been that way, Judge, so I don't know that he's.
All right, hello. It's too early for Christmas. Oh, no, I'm just joking with you. It seems that Christmas comes earlier and earlier every year and they put everything out. But, all right, so what we're here for today, the state, were you able to tender an offer? Okay. All right, sir, how old are you?
6.
All right, you're 26. Get the calendar here. All right, Norma. On this case, can you set it for a plea deadline date, the week of December 16th?
I'm probably leaving town December 13th, so a couple days before that.
All right, Norma, then can you put it on December 10th?
Then I have the dentist, so maybe the 11th or the 12th.
All right, December 12th.
Thank you, Judge.
All right, once you sign the reset form, you're excused. On that day, you need to let the court know whether or not you've reached an agreement. If not, your next setting will be a trial setting.
Already.
All right, thank you. And are you ready to proceed on the?
Yes, Judge, we are ready to proceed.
All right, we're going to go on the record. Court is calling 2024 CR 6204, State of Texas versus Andrew Mark Leha. Can I have parties announced?
Jason Garrett, state your honor.
Teresa Garcia for the defendant.
And are you Mr. Leha?
Yes, Your Honor.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney and did you understand it?
Yes, Your Honor.
Are you the same Andrew Mark Leha who was placed on community supervision in 2024 CR 6204 for the offense of theft $2,500 to $30,000 on July 9th, 2024 for a term of 2 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor, violated condition number 1 on or about the 30th day of September 2024 in Dale County, Texas. The defendant, Andrew Mark Reha, committed the offense of theft in violation condition number 1.
How do you plead to that? True or not true?
True, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion and sentence you up to 1 year in the state jail facility and up to a $500 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor,
Yes.
and that is to have, to deny the motion, continue on his probation and order moral or MRT therapy.
More recognition
Yeah,
there.
recognition. And then also judge a 10-day jail sanction starting from today. Also, the state will take in consideration 2 false numbers. One being that he pled true to today, which is 2024 CC 738906. And that is the theft. And then another theft that was previously supposed to be TIC, but was not, but we're included in this MTR is 2024 CC 738391. And that is also a theft. And Judge, also we're asking for a no contact order with all hunting goods.
That's correct, Judge. That is our agreement.
All right, so Mr. Leha, what I can tell you is I'm not going to follow that agreement. I'm going to revoke you. And let me just tell you, and people always say, you know, don't say too much on the record, but I want you to understand the reason why I'm doing it. I understand that they want the MRT, but how old are you?
46.
You're 46. So, I mean, you're at an age, you're supposed to know right from wrong. You can't take what doesn't belong to you. And you are on probation for a theft case. And when you were placed on probation for this theft case, there were cases that were taken in consideration. They were thefts. And then now you're back and now there's a new theft. So I don't think you're a good candidate for probation. So I'm not going to continue you. What I'm going to do is I'm finding number 1 true. I'll take into consideration 2024 CC 73890, 2024 CC 738391. There's to be no contact with any Home Depots. And I'm going to sentence you to 1 year in the state jail facility, give you credit for any time served. There's a $500 fine, time and money will run concurrently. And I think there was a no contact in that case as well. Let me see which person that was with or facility. And there's a no contact with Dick's Sporting Goods. All right, I'm going to show you what's entitled Trial Court Certification. of defendants' rights to appeal. Did you review that with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, you do have a right to appeal in this case, but that right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Your attorney actually did a very good job for you because now you're not looking at all of these other cases. So you should not have any more cases on your books when you come out, but you cannot take what doesn't belong to you. All right?
Sure.
All right, good luck to you.
Thank you.
All right. All right.
Oh, which number is that? 738-9. Ah, okay, so, all right,
Up to 7:01 this morning, but they're not here this afternoon.
all right. Norma, where is, family violence? All right, could you have them come down, please? They'll be right down.
Yes, ma'am.
All right, thank you. Just have a seat, Mr. Baker. Okay, we have a couple of things going on. The first thing we have in the night mag clause number that ends in 84. The bondsman has filed an affidavit to surrender surety.
Judge, because their affidavit was so sweeping and broad, saying he just didn't comply with rules, I asked you to deny it because it wasn't specific enough. We can't just have them every time they want to quit. You know, tell the court, oh, this guy's not obeying our rules. Let's at least know what it is.
Okay, on this
But
one,
you said, I'm sorry, Judge.
no, go ahead.
You said, well, find out if you can get them to stay on the bond. Well, we cannot get them to stay on the bond.
Oh.
So you're probably gonna grant that. I'd ask you
Well,
not
not
to.
necessarily. We shall see. They're saying that they say that he's a flight risk and will not appear in court as ordered. That's what they,
If,
put in.
if on the new cases, you were to order some sort of electronic monitoring device as a condition of the bond, that could address that issue. But, you know, it's sort of conclusory.
All right, well-
He's in college, he's a US veteran, he's,
well, this is what I can tell you. If you want to call the bondsman, because I do have a hearing set and it says the bondsman is to be
Yes.
present. So if you'll call the bondsman, and would there be any objection if they're able to zoom in?
none from me, Judge.
All right, so if you'll get in touch
Can I
with the
take that
bondsman,
paperwork back, Judge?
yes,
Thank you.
and we'll see what they're doing.
Yes.
Court is calling 2024 CR 2499 State versus Otilio Ruiz. Can I have parties announce?
Jason Garrett here for the state, Your Honor.
John St. Heiners for defense.
And are you Mr. Ruiz?
Yes, ma'am, I am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am, I did. Yes, ma'am, I have.
Mr. Oh, no problem. All right, so off the record for a moment. On his application for deferred adjudication,
Yes, Your Honor.
is there any objection to the court adding the last name Ruiz?
No, Your Honor.
Okay,
Thank you, Judge.
you're welcome. All right, we'll go back on the record. Mr. Ruiz, did you review the document entitled Application for Deferred Adjudication with your attorney? And did
Yes,
you
I did, ma'am.
understand it?
Yes, ma'am, I did.
And did you sign it?
Yes, ma'am, I did.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
I do waive the
State-
reading.
Thank you. State, it appears that you're proceeding on the indictment as presented.
That is correct, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ruiz, did you review the court admonishments with your attorney? Did you understand it?
Yes, I did.
Did you sign it in all the appropriate places? And state, if you need to be at your table to continue,
Thank you, Judge.
thank you.
Thank
Did you understand you're charged with injury to the child of a child or elderly or disabled person, bodily injury as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am, I did.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, I did.
Did you understand you have a right to jury trial, a right for you or your attorney? Just 1 second. We're back on the record. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand By entering this plea, you were giving up those rights?
Yes, ma'am, I did.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am, I do. Yes, Your Honor, I do.
Mr. Reeves, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
Yes, I did.
Did you understand it?
Yes, I did.
According to the plea, punishment is to be assessed at a $500 fine. The state recommends deferred adjudication. Did you understand that to be the plea?
Yes, I did.
And also, I'm unsure, I think this is family violence case, is that correct?
No, it's criminal trial division, Judge.
Somebody else did the paperwork for me, Judge.
Ah,
You can ask
okay.
me and I can open it up, yeah.
All right, no problem. I was just wondering. Because I was wondering whether or not there's an affirmative finding of family violence,
No,
but
no,
I see
there's
there
not.
isn't.
No,
Okay. All right, you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph?
Yes.
Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am, I did.
Counsel, have there been any such motions?
No, ma'am, no, Judge, there has not.
All right, outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be 120 hours of community service restitution, no contact with Conrado Espinoza, that's CONRADO, and the APSE course. Did you understand that those were recommendations from the state and the court does not have to follow those recommendations? Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Something.
State, any evidence?
Yes, Your Honor. City Exhibit number 1 with office attachments.
No objections, Judge.
All right, did you review the waiver with your attorney? Did you understand it?
Yes, I did.
And did you sign it in all the appropriate
Yes,
places?
I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, I did.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge, we are.
Anything you wish to say on behalf of your client?
Yes, Your Honor. First off, my client is the primary breadwinner for the family. He's the only one working. He has 4 children and 1 on the way. We would ask the court, if considering all these facts, if they would be willing to probate the fine.
Okay. All right, anything you want to say? What have we learned from this? What we've learned is that if you're walking in the middle of the street or if you're driving and someone honks their horn at you, you do not follow them to their home. And this was an elderly gentleman. I bet you were not expecting a dog to come out and come to his defense. What type of dog was it?
Pitbull.
All right. So you had a round with the pit bull that was protecting his owner. And how many times did the pit bull bite you?
3 times.
And where did the pit bull bite you?
My ankle and my thigh.
Was it painful?
Yeah.
I bet you won't do that again, will you? See, so here's the thing. All of this that happens out here with people driving or people walking and people honking their horns at you, you got to let that go. And you can't be following somebody to their residence because you never know what could have happened. And your attorney is telling me that you have children. That could have easily went, one, maybe you got rabies and died, or maybe the pit bull could have ended up killing you. Then who would be taking care of your children? All right.
Yes.
All right, this is what the court is going to do. There's a $500 fine that'll be probated,
Thank you, Judge.
2 years deferred adjudication. What do you do for a living?
Diesel mechanic.
Okay. Proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. 120 hours of community service restitution. I'm going to order parenting classes. Once he completes parenting classes, 60 of those hours will be deemed satisfied. And our order defensive driving. And once he completes that, the remaining of the 60 hours will be deemed satisfied.
Thank you, Judge. It's more than generous.
There's to be no contact with Conrado Espinoza, regular reporting by Zoom or in person, regular random UAs. And there'll be field visits 1 time per month for 2 months. Probation, is there anything else? Is there anything else you need from the court to be successful?
Okay.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, sir.
Did you understand it and sign it?
Yes, ma'am, I did.
All right, because this is plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am, I did.
All right, we can go off the record. In this court, communication is key to be successful. If you have an issue, let probation know about it. If you feel they're not addressing it, you can always come back to the court.
You can call me
Right.
too.
Okay.
And please tell me, Deputy Laura, I'm hoping they didn't put the pit bull down.
No.
Oh, they
Yeah,
did not?
No,
All right.
Judge.
Okay. All right, good luck to you.
Yes, ma'am, thank you.
Hello, Mr. Rice. How are you doing? All right, so today is the day for discovery. State, do you know if the discovery has been turned over?
I do not. I heard the defense counsel. See if they received
I
it.
believe it has, Your Honor. There are some videos that are currently being uploaded by Mr. Ariola, but it is my understanding that the discovery has been uploaded.
All right, so what I'm going to do is I'm going to reset this for discovery and also for the state to be prepared to tender an offer.
Yes, Your Honor.
And let's see. Norma, on this case, can we bring it back on December 19th for discovery? It's going to be for discovery and for the state to tender an offer to you, okay? And this, I'm putting it this time at that date, so that'll give your attorney a chance to look at everything and go over everything with you. As you know, holidays are coming up, so that's probably the last date I can get you in, okay? All right, you have any questions? All right, we'll bring you back on December 19th. All right, thank you.
Thank you, Judge.
You're welcome. Hello. Hi, I think this is the first time where I didn't have to sign an order for you to come over to court by force.
I don't think it is, Judge.
Oh, you think there are other times? Okay.
I'm certain that there was at least one other time.
Okay. How are you doing today? Good, how are you? Oh, I'm doing okay. All right, so we're gonna go on the record. Court is calling 2024 CR 6703A State versus Mariah. Am I pronouncing that correctly? Lopez. Could I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Orlando Castañon for defense.
And are you Miss Lopez? Counsel, have you received all discovery and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Ms. Lopez, did you review the true bill of indictment with your attorney? Yes, ma'am. Did you understand it? Does somebody need off the record? Do we need a mask for, I think we need a mask for somebody over in the box. Nobody's trying to get sick before the holidays.
It's happening.
Who is that over there with the cough? All right, let's give that to Mr. Baker. Do we need to double up on that? Those are pretty thin and flimsy. All right, we're back on the record. Court reporter, I'm trying to protect you.
Thank you, Judge.
All right. Deputy Laura, do you want to
what
like
it's worth,
sever?
He's always been that way, Judge, so I don't know that he's any sicker than he ever was every
Hey,
time I ever
doctor.
talked to him.
Dr. Patrick Montgomery.
I'm trying to alleviate some worry here.
People think that JD means that we're medical doctors. No. Yeah. All right, we're back on the record. You say that you reviewed the true bill of indictment with your attorney?
Yes, ma'am.
Do you waive the reading of the indictment?
I do, Judge.
Are you proceeding on the indictment as presented?
We are, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with burglary of a habitation? Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargaining agreement with the state, the court doesn't have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
You believe she has a rational as well as a factual understanding of the charges against her?
I believe she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 2 years in the prison. There are no applications. This will run concurrent with 2022 CR 8673. Take in consideration 2024 CR 5803. Did you understand that to be the plea?
Yes.
Defense is at the plea?
It is, Judge.
State is at the plea.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Judge.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Yes,
No objection, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
All right, how do you know these people? Do you know them at all? You can't do this, you understand? And what is happening with this other case that it's supposed to be running concurrently with?
You've already sentenced her to that case. It was a revocation. It was,
Okay.
I believe back in May. I was not the attorney at that time.
All right. Court will sentence you to 2 years in the prison, give you credit for any time served. This will run concurrent with 2022 CR 8673. Take in consideration 2024 CR 5803. There's to be no contact with Alyssa Jade, Jade, Paez, Paez, or Samuel Reimers or Reimers, Rymers, or Brennan, Brennan, Alexander Cornish, or 3434 Oakdale. And that's San Antonio, Texas, 78229. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Yes. Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So anytime you're doing custody is a lot of time. So make sure you change your ways. If there's some issue with housing or something else, if I'm still here when you're released, you can come back here. If you can't find a place to stay, I'll pick up the phone and call somebody, okay? All right, good luck to you.
Thank you, Judge.
You're welcome.
There was somebody in my parking lot the other day,
Mhm.
and I saw her with a young child. And I went to go try and, we have a partial agreement. So that you know,
All right, court is calling 2019 CR 6683 State versus Joe Villarreal. Can I have parties announced for the record for the state
Jason Garahan, Your Honor.
defense?
The attorney record is Monica Guerrero. I work for Monica Joseph Dateson. We're ready to proceed on Mr. Villarreal's MTR.
All right, and are you Mr. Joe Villarreal?
Yes, ma'am.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Mr. Stateson, do you have any questions to ask him in regards to your representation?
And Mr. Villarreal, are you okay with me proceeding forward in place of Ms. Guerrero today? Yes, sir. Thank you.
All right. Mr. Villarreal, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Joe Villarreal who was placed on community supervision in 2019 CR 6683 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on August 1st, 2019 for a term of 5 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 2 on or about the second day of March 2023 in Bear County, Texas. The defendant Joe Villarreal did it in there illegally used a controlled substance, namely methamphetamine, and violation condition number 2.
How do you plead to that? True or not true?
True.
Your Honor, we'll waive the remaining violated condition.
Any objections to the waivers?
None.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, sentence you up to 5 years in the prison and up to a $1,500 fine? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
Partial, Your Honor.
All right.
An agreement on revocation of the, grant the motion and revocation, Your Honor. The state is recommending a lesser than 5 years to 4 years, which we're unagreed upon.
All right,
And I'm sorry, the state has also taken into consideration cause number 2024 PF 20151, which is possession case.
and defense, what are you requesting?
Your Honor, we had an agreement for grant the motion, revoke. We ask that you reform the judgment to reflect 3 years TDC instead of the 5 years. I understand previously he pled to 5 years. He agreed to that back in 2019. Mr. Villarreal is accepting responsibility on the new offense. He was homeless. He did not himself cause a disturbance on this new offense. It's a homeless encampment. Other people were damaging property.
Mhm.
He was, they identified him. He had a warrant for this MTR, but he cooperated, had a substance in his pocket, and the state is going to dismiss that case. He did SAT-F previously before he did treatment. He was going to church. Unfortunately, he had a relapse. He's really asking for his back time credit, the time that he had at SAT-F, which is 119 days. And he completed, I believe he completed because on the court summary, it says residential facility SAT-F, start date October 26, 2022 through February 22nd, 2023. And it says number of days completed, 119 days.
All right.
So
And
he's
state,
asking
you
for
may be
that.
excused.
So he's asking for the 119 days, and currently I've already checked with the court. He has 207 days credit in the Bear County Jail. He's asking for 3 years mercy on the court. If you could reform the judgment, reflect 3. If not, we're hoping that you would follow the DA's recommendation of 4.
All right, and probation, did he successfully complete SATA?
Judge, he completed the inpatient part of it, but not the outpatient part.
Okay,
And may I ask my client a question?
sure.
Mr. Villarreal, on the inpatient SAT-F, did you ever obtain a certificate of completion?
I did.
I'm sorry, you need to
Did
speak up.
I did.
You finished SAT-F
Yes, I did.
inpatient, completed it successfully?
Yes, sir.
If you want to ask him any questions, you can, Your Honor.
All right, so where did things go wrong? Because I know I tell people if there's some issues, all they have to do is contact their officer. Why didn't you contact somebody when you had a relapse?
I had an issue with my PO that I had at the time. I was trying to communicate with her, but to me, I felt that she wasn't trying.
Here's the thing, that doesn't hold water with me. You know why? Because I tell everybody, speak to your probation officer, and if you feel as though they're not addressing your issues, you can always come back to court.
I don't know how to like really explain myself to that extent, but I know you said that, and I know, I mean, I'm like a shy person, and I could have done that, but I just wasn't sure, too much sure. Like I said, it's not too much of an issue, but it's just, I guess,
All right.
discussion that we were having, you know, between me and my probation.
All right, so here's the thing, if you don't get your life together, one or two things are gonna happen. Either you're gonna end up continuing to be sent to prison, or either somebody's gonna be identifying your body because you got a hold of bad batch of drugs, all right?
Yes.
So you're gonna have to change,
Uh,
and nobody can help you if you don't want it for yourself, okay?
most definitely.
All right, the court is finding two true. The court will grant the motion revoke. Take in consideration 2024 PF 20151. Court will sentence you to 4 years in the prison, give you credit for any time served, and credit for any successful completion of inpatient treatment. And I'll order the therapeutic community. In order to be in that program, you'll have to request it as well. I have no jurisdiction to force them to place you in that program, but it's to help you maintain your sobriety.
Yes,
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
yes, ma'am.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations that are in the motion, not the fact that you are on community supervision. Do you understand?
Yes.
All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Copies.
All right, are we ready on Baker?
She gave you your status.
Yep, the bondsman is on the Zoom.
Baker, I wasn't telling you what you got. Hello. Yes. All right.
Hello, Mr. Rodriguez.
Okay, yes, ma'am.
All right, I can't hear you.
Yeah, I had my mic off. Can you hear me?
All right,
I'm trying to get the volume up so I can hear you. Okay.
all right, I think I hear you better now. All right, what we're here for is you're asking to be taken off of this bond. You filed an affidavit to surrender surety.
Yes, ma'am.
Are you aware of Mr. Baker's case?
Yes, ma'am.
All right, so we'll proceed. The court is calling, let me see. And I just have an affidavit to surrender surety on one of the cases.
Yes, I had two cases. One of them is completely paid off, and he just paid
Okay.
on the other.
All right, so the one that he's seeking is the one that we're going to proceed on. Court is calling NIGHTMAG number 7240884, State versus Richard Nelson Baker. Can I have parties announced for the record for the state?
Raymond Saldana.
Defense?
Pat Montgomery.
And are you Mr. Baker?
Nelson, Baker, yes.
Yes. All right. Is your first name Richard?
Yes.
Okay.
You said Nelson.
Yeah, Richard Nelson Baker?
No, ton.
Ah,
No
we need
S.
to correct that then, because it's listed as Nelson. All right. And the bondsman has filed an affidavit to surrender surety. And defense, are you objecting to the court signing that?
I am, Judge. I'd like you to leave the bond as is and address the new bond, which is currently, it's not here right now, but it's currently a remand without bond. Mr. Rodriguez isn't necessary for that case.
Okay. All right. So with regards to this case, Mr. Rodriguez, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Manuel Rodriguez, Eagle Bell Bond.
All right, so Mr. Rodriguez, the court is in receipt of an affidavit to surrender surety. Defense counsel says that it is not clearly defined the reason for you're wanting to be removed from the bond. And what you put in the affidavit is that you believe he's a flight risk. Are you able to expound for the court, please?
Yes, the reason on the fight, this is the standard statement of on the app.
Okay, I'm sorry,
None
just
of
one
us,
second. All right, are you able to move closer to your microphone?
Oh, can you hear me?
All right, let's do this.
Let me do the output, see what's wrong with the
Okay.
output speaker.
All right, let's do this. Is there any objections if he were just to call my phone and I can put him on speakerphone, but since everybody has seen him, any objections to that?
Probably hear him better that way, Judge.
All right.
No objection.
Okay, Mr. Rodriguez,
How is
can
that?
you text, repeat yourself now?
Yes, manual, this is manual. I just found it's actually under the input. I guess I was looking at the wrong one.
All right, to the court report, are you able to hear him better now or no?
A little better, yes.
All right, can you just say something? Let's see if we can get you.
My name is Manuel Rodriguez with Eagle Bell Bonds.
Is that good or do you want him by phone? All right, can you put in the chat box your number and I'll call you?
Okay, where's the check box?
Oh, yes. And if you need to sign off to answer the phone, you can. And I'm gonna call you right now.
You have my number?
Yes, Norman's giving it to me.
Yes, ma'am.
All right, thank you. All right, so can you explain why you do not want to be on the bond?
And it didn't look like nobody was gonna bond him out. And I've been having problems with him as far as his payments are concerned from before.
All right, and with regards to what you put in the affidavit about the flight risk? Okay, so can you explain to the court and to the defense counsel, what is your reason for not wanting to be on this bond?
I've had Richard on bond for over a year now. My biggest problem with him was at first was calling in and making his payment. You know, we had two different bonds. One of them was completely paid when his mother got him out. The second one, he was gonna make payments. And at first he wasn't calling in nor making his payments at all. So when he got arrested and he wasn't getting vented out, I waited. I think it was a week or two, maybe longer, because he had promised to make a payment on the 2nd of November, and he had gotten arrested and he never made that payment. And these were back. So since he wasn't getting bonded out, I just did a surety surrender. I didn't feel it was right for me to do surety surrender on both bonds because one of them was paid off completely. So, you know, I figured on my own right, I figured I only had the right to get off on one of them because he was refusing to pay.
All right. Any questions, defense?
What kind of payments was he supposed to be making?
Originally, and I've got the regiment here. It was $500 a month. Started on the 10th of November. His first payment that he made was a $250 payment on February the 2nd. The second payment was of $500 on the 29th.
things in it, then the court will hear it. And if it's correct, then I'll have the option of granting it. But just this specific one where it says it's a flight, he's a flight risk, I think the testimony is that people misspoke. I'm just gonna say misspoke and put something unintentionally in the affidavit. That's how I'm just gonna put it. And so are you withdrawing that? And then you'll refile another one if you wish to refile another one. All right, so that will be withdrawn. All right, thank you so much.
Thank you, Mr. Rodriguez. May I address the court?
Just one moment.
Yeah, I'm just gonna keep that.
All right. consensus? If not, we can just go forward through using police reports.
Let's go forward using police reports.
All right, so I don't have any.
I'm ready, right in front of you. Wow.
All right. Any objection?
Not judge, not for the purposes of the bond hearing. This is his brother, Your Honor.
Okay. All right, the court has reviewed the police report.